Welcome back to the Constitutional Clarion. This is just a quick, spontaneous video because earlier today, my time at least, it was announced that Bill Shorten, a Commonwealth Minister, had accepted an office as Vice-Chancellor of the University of Canberra, but would continue to serve as a parliamentarian and a minister until February next year. Now, as a constitutional lawyer, my mind in those circumstances drifted towards the wonders of, and the horrors of, Section 44 of the Constitution concerning disqualification. The notorious Section 44 not only disqualifies MPs with dual citizenship, but it also disqualifies anyone who holds any office of profit under the Crown. One of the purposes behind the provision was to prevent governments from conferring lucrative offices on parliamentarians so as potentially to influence them in how they make their votes. So, does that section operate in relation to Bill Shorten? The first question is whether the acceptance of such an office, even though a person has not yet commenced work in that office and is not yet being paid for it, is enough to disqualify that person as a Member of Parliament. This is a disputed question that hasn't yet been resolved by the High Court. If one goes back to the controversial Gare affair back in the 1970s, and on this see my earlier video on the Night of the Long Prawns, the Whitlam government argued that Senator Gare became disqualified upon accepting an appointment as ambassador to Ireland, even though he had not yet taken up that office. In particular, the Solicitor General, Maurice Byers, and the Attorney General, Senator Lionel Murphy, contended that Gare was disqualified from membership of Parliament at the time that he had accepted the appointment, but even though he had not yet commenced duties under that appointment or received a salary, and his appointment was expressed to be operative from a future date. While a constitutional challenge in that case was commenced, it never came to court because a double dissolution of Parliament was instead held, so the question became irrelevant. The only authority on the point is a Western Australian case under an equivalent state constitutional provision, where the court held that there was a distinction between being appointed to an office and actually holding that office. But whether, of course, the same approach would be taken by the High Court remains to be seen. Would the Albanese government today repudiate the views of Whitlam, Murphy and Byers from the past? They probably would, actually, but as I will explain, there's actually no need to put that issue to the test. That is because the other question is whether the position of Vice-Chancellor of the University of Canberra is an office of profit under the Crown. Now, it's certainly an office. It's also one of profit because remuneration is attached to it. The High Court has described an office of profit as, quote, a position of a public character constituted under governmental authority to which duties and emoluments are attached. Now that does seem to cover a sort of office like a Vice-Chancellor of a public university. But is it under the Crown? And for that matter, which Crown counts for these purposes? First, we know that offices held under a state crown can still trigger the disqualification of federal members of Parliament. It doesn't have to be an office under the Commonwealth Crown. Phil Cleary found this out to his disadvantage in 1992 when, in the case of Sykes and Cleary, the High Court held that being a state school teacher, even when on unpaid leave, was enough to make him incapable of being chosen as a Member of Parliament. What then is the status of the University of Canberra? Well, it was originally established as the Canberra College of Advanced Education by the Commonwealth under the Canberra College of Advanced Education Act of 1967. It was later elevated to the status and the name of University of Canberra from the 1st of January 1990. Jurisdiction for the university, however, was passed from the Commonwealth to the Australian Capital Territory in 1997 by the Education Legislation Amendment Act of that year. So it now falls under the Crown of the Australian Capital Territory. Universities, however, are largely independent of the governments that establish them. So is an office in a university an office of profit under the Crown? We don't have direct authority on that proposition, but the most analogous case is one that deals with whether or not a person who holds an office in a local government, as a mayor, for example, holds an office of profit under the Crown. That issue arose in a case called Re Lambie in 2018. It dealt with the question of whether the Mayor of Devonport in Tasmania, Stephen Martin, held an office of profit under the Crown. Now in that case, of course, it wasn't the Crown that appointed him as Mayor of Devonport because he held an elected office, so appointment wasn't relevant in those circumstances. The High Court then applied a test of whether the executive government has effective control over the continued holding of the office or continued profiting from it. This included control over the security of a person's tenure in that office and their remuneration, as well as the means by which they might be removed or suspended from that office. In Re Lambie, the High Court held that the Tasmanian local government legislation did not show such a degree of effective control as to characterise the office of Mayor as being under the Crown. The University of Canberra is now governed by the University of Canberra Act 1989 of the Australian Capital Territory, which took over the Commonwealth legislation, including the date of that legislation. Section 25 says that the Council of the University appoints the Vice-Chancellor of the University, and that Vice-Chancellor holds office for the period and on the conditions that the Council decides. So who controls the Council is critical to this issue. Now the Council is comprised of the Chancellor, Vice-Chancellor, the Chair of the Academic Board, 2 elected staff members, 2 elected students, and 8 persons appointed by the Minister. That means that ministerial representatives do have a majority on the Council. So might it be argued that the government can assert control over the appointment, removal and remuneration of the Vice-Chancellor? Interestingly, the Minister is actually prohibited from appointing members of the Commonwealth Parliament or indeed a state or territory legislature to the Council as one of those 8 members on the Council. However, that restriction is not extended to the appointment of the Vice-Chancellor. More importantly, Section 12 capital A says that in exercising the functions of a member of the Council, a person must act always in the best interests of the university as a whole, act honestly and for a proper purpose, avoid conflicts of interest, and exercise reasonable care and diligence. It appears, therefore, that the ACT Executive Government does not control the 8 members of the University Council that it appoints because they have a higher obligation to act in the interests of the university rather than on instruction. And therefore, it's unlikely that the office of Vice-Chancellor of the university is an office of profit under the Crown. On that basis, there does not seem to be a real risk that Bill Shorten is disqualified from Parliament through accepting this office, and accordingly he may continue to sit and perform his duties until February when he actually takes up the office. I hope you found that discussion of Office of Profit under the Crown quite interesting. For those of you who actually want to know more about it, I wrote a quite detailed paper on it for the Commonwealth Parliamentary Library some years back. It's available online, and therefore I will put a link to it in the description box down below for anyone who wants to read it. Thank you again for watching the Constitutional Clarion, and as always, I look forward to seeing you next time. Goodbye.